So, back in 2018, Canada made cannabis legal right across the country. But what happens when a province decides to hit the brakes and say, hold on a minute, we're going to break down a huge Supreme Court decision that put Quebec's rules head to head with federal law? So, who came out on top? Let's get into it. Seems like a pretty straightforward question, doesn't it? The federal government gave the green light, so you'd think growing a couple of plants at home would be okay everywhere. But this is Canada. The answer is way more complicated than a simple yes. And here's the heart of the problem. Ottawa's Cannabis Act says you can grow up to 4 plants for yourself. But Quebec's law, it says absolutely not. 0. A total ban. This direct clash is what set the stage for a massive legal fight that went all the way to the top. To really get what the court decided, we have to look at the rulebook for Canada itself. Seriously, this was never just about cannabis. It was a major test of who holds the power, the federal government or the provinces. And it all comes down to this one super important idea, the division of powers. Just think of it like this. Way back when Canada was formed, the Constitution gave different jobs to different levels of government. Ottawa gets a list of things to do, and the provinces get their own list. And for the most part, they're supposed to stay in their own lanes. For instance, the federal government handles criminal law for the whole country. That's their job. It's why they were the ones who could decriminalize cannabis in the first place. But the provinces? They're in charge of stuff like healthcare, property rights, and other local issues. The real drama starts when those responsibilities seem to overlap. So, the whole case really boiled down to one huge question for the Supreme Courts. By banning home growing and handing out fines, was Quebec basically writing its own criminal law? Was it stepping on the federal government's toes? Or was it just doing its job of managing local health and safety? So to find the answer, the court had to put Quebec's law right under the microscope. They couldn't just read the words on the page. They had to dig deep to figure out its true purpose, its real reason for being. And for a job like this, they have a special tool called the pith and substance test. Now, it sounds a little fancy, I know, but it's basically the court acting like a detective. Their mission is to find the law's true identity. Is it secretly a criminal law wearing a disguise, or is it something else entirely? Here's how that works. It's a 2-step process. First, the court looks at the law's purpose. What was the government trying to do? And its effects. What does this law actually do in the real world? Then, once they figure that out, they classify it. They decide if it belongs in the federal box or the provincial one. So, what did the detective work turn up? Well, the court concluded that Quebec wasn't trying to sneakily make cannabis a crime again. Nope. Its real goal was all about public health and making sure its provincially run stores, the SQDC, worked effectively. The ban on growing at home? That wasn't the main point. It was just the method they chose to push everyone toward a single, government-controlled source. And this brings up another cool legal idea called the double aspect doctrine. The court basically said that a subject like cannabis has 2 different sides to it. Ottawa can make laws about it from a criminal angle, and at the same time, Quebec can make laws about it from a health and local business angle. Both can be totally valid. Okay, so the court says Quebec's law is legit. That's it. Case closed, right? Not so fast. There was one last massive question to answer. Even if the provincial law is valid, can the federal law just override it? Play a trump card, so to speak? This gets into something called federal paramountcy. It's a principle that says when there's a direct head-on conflict, the federal law wins. So the court had to ask, is it literally impossible to obey both laws at once? Does Quebec's ban completely sabotage the entire purpose of the federal law? And this right here, this is the knockout blow in the whole decision. The court made a crucial distinction. It said the federal law didn't give Canadians a right to grow cannabis, it just created an exemption from a crime. Think of it this way. Ottawa said, we're not going to charge you criminally for this anymore. What it did not say was, you now have a guaranteed, untouchable right to do this no matter what other local rules say. And hey, don't just take my word for it. The court was incredibly clear on this. Here's a direct quote. The purpose of the federal act is not to create positive rights. They put it in black and white. The goal was decriminalization, not forcing every province to allow home growing. So you see where this is going. If the federal law doesn't create a right that's being taken away, then there's no real conflict. Someone in Quebec can easily follow both laws. How? By simply not growing any plants. This way, they respect Ottawa's decision not to make it a crime, and they respect Quebec's stricter health rule. Both laws can live side by side. And with that final piece of the legal puzzle locked into place, the Supreme Court was ready to hand down its verdict, a decision with massive implications for how Canada is run. And the ruling was a clean sweep. The appeal against Quebec's law was dismissed. The court said the ban was constitutional, totally valid, and didn't clash with federal law. So the bottom line? Quebec's zero-plant rule is here to stay. This landmark decision came down on April 14, 2023. It settled years of legal back and forth and sent a really strong message about the power provinces have to make their own rules. And that's why this is so important to understand. This case was never really just about cannabis plants. It's a huge statement about how our country works. It confirms that provinces can set stricter local rules for health and safety even when the federal government is active in the same area. Which leaves us with a pretty fascinating question to think about. Now that the Supreme Court has drawn this line in the sand, what's next? What other areas, things like environmental rules, healthcare policies, maybe even how we regulate the internet, could become the next big constitutional battleground between the provinces and Ottawa?